Hi.
Hi, everyone.
Hi, everyone, and thank you for joining us today on this legal session. We have no doubt that all of you have lots of questions about legal challenge in the gaming industry, and we're there to help you with it. So first, let's introduce ourselves. Paul, do you want to start?
Yeah, sure. Hi, everyone. So my name is Paul Lanois. I am a director at the law firm Fisher, and I advise primarily in the area of privacy, technology, and cybersecurity law.
And my name is Laura Berton. I'm a partner at law firm Phil Fisher as well. So we are a European law firm, which you may hear from our accent. Paul and I happen to be French, but we're also English qualified, and Paul is also US qualified. So don't worry, we're not just European lawyers. And I'm a specialist in tech and digital regulation and focusing on digital industry, amongst which the gaming industry. So we know that we only have 15 minutes, and there's a lot of topics to talk about. So we expect that amongst all of you, there may be developers, publishers, distributors, retailers, manufacturers, digital platforms, and quite a lot of different audience. So what we're going to try to do is make it as broad as possible, but bring you newer topics rather than go back to the basics of what you know. So we're really going to focus on the future of gaming from a legal standpoint, rather than looking at the issues that all of you already know about. Okay, I'll start sharing the presentation. And full screen. So as you can see, we have quite an ambitious agenda. There was a lot to say. So we'll try to cover, privacy, and we're not going to go deep into what the GDPR is. We expect that you all know about it, but there are a few things that we've seen recently that we think you should know about. We will have a look at digital regulation from Europe, which is at the moment the most active area of regulation, new regulation that affects the gaming industry. Look, of course, loot boxes, PEGI ratings, VR-specific issues, the resale of digital content, and consumer protection. So there's quite a lot to say, and we have to keep it brief, but it's really, the purpose of this is really to give you an overview of what you should pay attention to. It's really just to reduce the unknown unknowns, rather than for you to know everything in detail. But of course, feel free to ask us at any time later or during the presentation if you have any question. And if we don't have time to deal with it on today's talk, then we'd be happy to take it offline. So I think, first of all, just to recap a little bit, a lot of the gaming industry is global, meaning that even though games may emanate from one continent or one country, they can be played usually on various platforms and all around the world. The problem is that regulation usually is done on a country per country basis, not even on a territory. And for some places like Europe or the US, despite the fact that there are federal laws at US level, there are also state laws, and the same thing for the European Union. Although we do have European law, a lot of its implementation, in addition to national law, will be done at the country level. And it makes it very, very difficult to basically to comply with all of this legislation. So Paul, what's happening at the moment in the world?
Thanks, Laura. Well, as we all know, we are living in a pandemic situation, and this means that there has been a strong increase as well in terms of video game usage around the world. There was a survey, for example, by Verizon recently, which showed that video game usage in the US went up by 75% during the quarantine, and then Unity Technologies as well. Just a few weeks ago, they released another survey, and they found that there was an increase in 46% in the daily active users of desktop games and 17% increase in mobile gaming this year. And the reason why I'm bringing up all these figures is that, well, we all know that because people are confined, people are staying in, that there is a higher usage more people are turning to video games as their source of entertainment. And this unfortunately also means that there is also more regulatory scrutiny because, well, um, regulators are looking more into what's going on. And for example, in China, there has been a recent wave as well where the Chinese regulators are checking as to whether games have been games published on the App Store in mainland China, whether those have been properly registered. And this appears in the slide here as well. There was a sort of recent media report as well that there's going to be a more name verification, which is being conducted in China simply because there are laws in China surrounding video game usage. They want to limit how long people spend online. Uh, going to the next slide. Uh, you may be surprised. Well, why do we have the slide with uh, basketball, Call of Duty, Fortnite? Well, earlier this year, there were some cases surrounding those video games, and just to give you a very short background about it, well, as games tend to become more and more realistic, we have advanced graphics nowadays, and because we try to depict how things are in real life, so you will have uh, basketball players who would be as realistic as possible. You would have the depiction, for example, of the tattoos, or otherwise in Call of Duty, you want to reproduce the same um, vehicles which have been used in modern conflicts and so forth. And there has been a lot of litigation as well concerning licensing topics. To what extent can you actually reproduce for example, tattoos on basketball players, or to what extent you can reproduce vehicles in video games. I'm not going to elaborate too much on that. There is a link anyway on the slide here for those who are interested to read more on the topic. Going on to the next slide. Oh, I think this is for you, Laura.
Did you want to add anything, Paul?
No, not at this stage.
Okay, so let's dive in. So I did promise we're not only going to talk about Europe. However, as it happens, a lot of the regulation at the moment in the digital world is happening in Europe, and this is why you need to know about it. So all of you know about the impact the GDPR has had on your business. And what we see now is a wave of new digital regulation emanating from Europe, which will have a similar impact. So again, although this is not meant to be Europe-centric, as it happens, the US at the moment is not really willing to legislate too much on digital by fear of restricting business, I guess, or by lack of political will. I'm not sure. There are other things to do, as Paul mentioned, the more targeted Chinese initiatives. But in terms of the regular digital, the EU is really the one to watch. So just so that you understand, the EU has, over the last few years, promoted a European digital agenda. And they have delivered. So it's not a willful agenda that has been tentatively fulfilled. It is actually a very serious goals that have been set by the European Union, and most of their initiatives have been followed up over the past 10 years. We have now an updated digital agenda, and the European Union is taking it as seriously as for the past 10 years. So some of the ones that you should be concerned about is, of course, the privacy. And so again, as I said, we're not going to go into what is the GDPR, but what are people still not getting, and where are the key triggers for regulation and for, well, the key compliance issues now.
Thanks, Laura, and I'm sure everyone heard about the GDPR, and I'm not going to go back into details as Laura mentioned. But then one of the points I really wanted to emphasize on is and the reason why I want to emphasize on this point is that even earlier this week, when I've talked to some developers, I think there's still a lot of misunderstanding on the concept of personal data, because a lot of game developers, they would assume that we are not collecting any names, we're not collecting any physical addresses, and therefore the argument is to say, well, we're not collecting any personal data, so the GDPR and other data protection laws don't apply to us. And if they're talking about a single player game, then of course that is likely true. But then in many cases as well, we would have games which have an online connection. There would be a user account and so forth. And in those cases, it's not really true that no personal data is collected, because the GDPR clearly states that as long as you are collecting any information which relates directly or indirectly to an individual, that is personal data. And the GDPR expressly includes as well IP addresses, online identifiers, and so forth. So even if you have, for example, a username which doesn't include any real world name. So if I take a username like super secret squirrel 007, you would say, well, wait a minute, super secret squirrel 007 doesn't have any real name. I don't know who's behind that. It's just a nickname that someone came up with. I have no way of saying that this super secret squirrel is this person in real life. Well, that may be true, but then the reality is that under data protection laws, well, you may, in addition to having super secret squirrel 007, are you collecting other information like the IP address or any other information which may directly or indirectly tie you back to a person, even if you do not know who that person is. So do you have any tracking technologies? Do you have any cookies or whatever? If you have any of those, then you would actually be collecting personal data, and you would have to be mindful of that. And in addition to having account names, maybe you have leaderboards, maybe you have in-app purchases, DLCs, and so forth. And in many of those cases, this would mean that you would be probably collecting personal data under data protection laws. And it's not uncommon, for example, to see telemetry in relation to gameplay actions, such as session start, stop times. Maybe you collect system information as well. For example, you want to know, well, what operating system is being used, whether the video card type is AMD, NVIDIA. Maybe you want to know whether the user is using DirectX 11, DirectX 12. Maybe you would have in-game economics, where you would try to collect information to know how to improve the in-game economics. Do you collect other statistics, for example, game settings, and so forth, in order to improve the gameplay experience, or to increase how the AI performs? And in those cases, well, the data protection laws would apply. If I take the example which appears on the slide, it's now increasingly common as well to have online multiplayer games to include an anti-cheat solution, and the anti-cheat solution would be to ensure that users are not cheating. Maybe users want to gain an advantage over other players by having, for example, wall hacks, so that they can see through walls. They can hear you coming from miles and miles away. Maybe they want to have an auto aim, so that when they aim the gun, you would shoot directly, and they don't have to exercise any skill in the shooting. And those are just common examples of what some hackers would do to cheat in the game. And of course, that ruins the whole gaming experience for others, because, well, if you are playing a multiplayer game and within 10 seconds you immediately are shot and you immediately die because someone is very skilled and can see through walls and so forth, well, it's not really going to be an enjoyable experience for you. And this means that many users would just leave the game. They would be unhappy. They would voice their discontent on discussion boards, Discord, or whatever. And this is overall bad. And so that's why a lot of game developers, they have looked into integrating anti-cheat solutions for online games. And this does raise I would say a certain data protection concerns, because, well, if you are even if you say that you don't have any information about the name, well, in order for the anti-cheat solution to work, you are probably collecting information such as the IP address, hardware settings, what software processes are being run at the same time, to what extent are those software processes interconnecting with the game, or otherwise, to what extent do you have known software which are running at the same time, and so forth. And and because you are collecting lots of different types of data, there have been examples, even from a commercial perspective. So even setting aside the data protection laws, there have been examples where when a game developer has not fully disclosed what is going on, or otherwise if customers are afraid about what's going on because they don't understand what is going on and why this is being done. There have been some instances where there has been a big backlash against certain games, and the Doom Eternal is one of those examples.
Yeah, and I think the key thing, therefore, is to remember in-game data, even if it's not personal, even if you don't see it as personal data, is quite likely to be personal data, and you have to comply with the GDPR even if you're not intending to sell it. And the repercussions, as Paul was saying, they're not just in terms of getting a fine, but also in terms of PR. And these are the key things that we see at the moment, people forgetting. So most people are trying to comply and they're being quite good, but there's lots of things that they just think are not applicable to them when they are. So just be wary of that, because there's a lot of activism, like personal data activists, who are likely to take cases up and publicize what they see as breaches.
That's a very good point. And as you mentioned, Laura, one of the big concerns for the gaming industry is not just strict compliance with the law. It's also like you mentioned, the PR. It's the backlash which may come up if people just don't understand what's going on. And generally, when users don't understand what's going on, they tend to fear the worst, and that leads to a lot of unrest, and it leads to review bombing. It leads to bad press generally.
Yeah. Okay, so what about consent? What are we seeing at the moment that people are not doing?
Yes. So in relation to consent, we have the GDPR, but then there is also the e-privacy directive, which applies in the European Union, and those two pieces of legislation regulate the collection of or access to information stored on a user's device. So if you have any tracking technologies, and not just cookies, uh, this this would and this would mean that you would have to comply with the GDPR and e-privacy directive. For example, are you having any advertising? Do you have any analytics going on? Do you collect and access data from users' devices? And if that's the case, then you are required under the law to provide users uh, with a notice. You have to provide them information as to what you're doing, and you need to obtain their prior consent before you can actually use tracking technologies. And under the GDPR, in order to obtain a valid consent, the consent must be freely given, it needs to be specific, it needs to be informed and unambiguous. So this means that the consent is to take place before any tracking technology is being deployed. And the reason why this slide includes certain game screenshots is that we wanted to show as well that this this requirement is something which more and more game developers are being aware of. But then in many cases, there's still a lot of misunderstanding, I would say, as to as to what it's actually required. For example, on the first picture, we have a developer asking the users to provide a consent before advertisement can be served, and that's good. It gives the user the option to reject the cookies to use the app without targeted advertising or without ads entirely. So that's good as well. There is a link to a privacy policy. That's good. But then there is no reference at all to any tracking, and therefore this would not comply with European data protection laws. If we look at the second picture, well, we have the same issue. There is still no reference to tracking, and the bigger problem here is that the user has no genuine choice, because it's either I accept or not. There is no real choice provided here. And if you look at the third picture, well, it's the same. There is still no reference to tracking, and there is also no genuine choice here, because, well, I accept, and you could say that, well, there is very small, just underneath the I accept, there is there is a link if you don't really accept it, but then because it's the font is extremely small and not the same size or the same visibility as the I accept button, data protection regulators have actually stated that that would not constitute any real choice under data protection laws, and so this would not be this would not be allowed. Moving on to the next slide, some of you may be wondering, well, why do we talk about how the consent is being presented? Is it really that important? Because, well, in the text of the GDPR, there is no requirement about size or font or whatever, and that is true in the text of the GDPR. However, data protection authorities such as the CNIL in France, they have actually issued guidance in relation to how consent should be obtained. They have released and the what you see on the on the slide deck is actually something that I a screenshot that I took from the French Data Protection Authority's guidance, where they actually go very much into detail as to what they consider is proper consent in mobile apps, where they would talk about the size of the buttons, they would talk about the placing, the types of length, and so forth. So it's really something which is very important to be mindful of, because the data protection authorities, they are looking more and more into practices which are being done online, in particular in relation to mobile apps.
Okay.
Moving on to very quickly, children privacy is a topic which is often overlooked, but then because we are dealing with video games, it is, I would say, paramount to the industry to consider children privacy, because in many cases, even if we take a game like Angry Birds, for example, where you would say, well, there have been studies showing that the primary audience of the game is actually young adults. So why do we have to consider children's privacy? You have, for example, in the US, the FTC, which has clearly stated that, well, even if a lot of users are adults for a specific game, the design of a game, for example, if you use cartoonish characters and so forth, those would often be seen as well as means which could mean that your game is actually also being targeted under the law as targeted towards children. And there have been a number of cases which are shown here on the slide, where you would have game developers which have been fined by the US FTC because according to the FTC, they did not comply with children privacy. And the fines can be quite important. We're talking about, for example, in the case of YouTube, it was a fine of 170 million. But then, even for smaller app developers, 150,000 for Hyperbeard, and then there was a Swiss digital developer which also had been sanctioned by the FTC.
Oh, so basically, watch out. And these are things that are happening now. So even for companies who felt quite comfortable that they were compliant.
Mm-hmm. And the last two items on the screen, those were from last year, but the top two are actually quite recent. They are both from this year, so watch out.
Definitely. Thanks, Paul. So let's look at beyond the privacy angle. What is the European Union doing now that is impacting you in the gaming industry? So first of all, you may have heard about the hugely controversial European Copyright Directive that was passed a year ago, and that it's a directive rather than a regulation. So that means that it has to be enacted by each member state by May 2021. It's not applicable directly into national legislation in Europe. And that differs from the GDPR, which is a regulation and therefore is applicable directly, although member states can choose to add a few things. That means that basically regulations offer a lot more cohesive means than than directives, unfortunately, but it makes Directive easier to get through Parliament. So what does it do? It basically regulates copyright in the digital environment and basically tries to give rights holders a way to make money and to benefit from their online work, considering the current issues. So as a lot of you may know, there has been in Europe the e-commerce directive and in the US similar legislation that have afforded safe harbor to online intermediaries in relation to user-generated content and content posted on their websites that they were not responsible for. And this has been fantastic, has been a great growth environment for the internet, which has grown tremendously over the past 20 years. But what it means is now with the new business models that we have, whether all the big platforms, of course, YouTube is one of the biggest ones that comes to mind, but there's lots of other online platforms that allow the uploads of videos and music or even written text on the internet. It basically has meant that big platforms, although they benefit from copyright infringement, they do not have any responsibility for it beyond taking that content down as soon as they hear of it. So, and that means that rights holders struggle to get paid for their work. So the European Copyright Directive is really aiming to bring up to date copyright legislation in digital environment. So the way it affects you in gaming is that games, of course, consist of various copyright works, including, literary works, artistic work, musical work. So there's a couple of ways in which you may be affected. So if you are a platform streaming, or if you are a copyright owner of a game, so you'd have, for example, your work may be streamed online, and in a way, it's great because you get advertising. On the other hand, you don't get paid for this use of your copyright. A lot of the logos, screenshots of the games may be published in different places, again, without getting payment for this work. On the other hand, if you are an online content sharing service provider, you may be benefiting from all these uploads of videos of games, of videos of people playing, and not paying license fees for these videos. So I think, again, the people who have to be concerned about and start looking into it a bit more would be, any company that provides streaming services, gaming platforms, social media, any content recognition or filtering technology service providers, as well as copyright owners. And I think now we have about 9 months before this legislation comes into place. So we won't have time, as I said, to go deeply into it, but what we'd recommend is for you to have a look at the EU Copyright Directive and see how it's affecting you. So we've put, every time, as we know we didn't have much time, we've put additional reading that we suggest if you want to learn more about this. The next new digital regulation that is important for you to know, especially, well, in both ways, it is in two ways, is the Platform to Business Regulation. So the Platform to Business Regulation recognizes the fact that not all business-to-business contracts are the same. It recognizes that online platforms have a a stronger bargaining power than the smaller business users. So in order to basically not quite reverse the balance, but make sure that smaller business users have more of a fair say in relation to their platform terms, the European Union has issued this new platform to business regulation. So what it will do is, in the same way as you've had consumer legislation, this will be regulating online platforms and their business users regulation. So again, think about which online platform are selling, publishing your games, which stores, online stores will be doing this, which social media platforms, which comparison tools, which marketplace. And this is aimed to balance your rights. It will offer the possibility for smaller game publishers to fight unfair terms and unfair trading practices in platform to business regulation. And every non-compliant terms will lead in these terms being null and void, in addition to having access to mediation and court system. So again, this is a regulation that's brand new and that will affect you depending on, which side of the coin you are. So there's one thing that, of course, you need to know is that the only platforms that have to comply, it is a European legislation after all, are the platforms that provide basically their services to business users established in the EU, with the goal to offer goods and services to consumers located in the EU. So I think in our global market, that means most major platforms. But again, make sure that you comply. If you do, then I think this is a much needed legislation to make sure that we address what has been over the past slight difference of bargaining power between game developers and publishers and the platforms that publish the games. Again, if you want to have a bit more information, please have a look at links, and would be happy to, I think, circulate the presentation afterwards so you can have access to these. Okay, and the last one that, again, we're not going to talk at length on, but it's good for it to be on your radar, is the Digital Services Act. So again, as part of the EU reform of the digital industry and digital framework, the European Commission is looking to upgrade liability and safety rules for online services, for online service providers and online intermediaries. And a lot of it will impact on the gaming industry in relation to also user-generated content, basically social media. So the problem at the moment is, again, similarly as for the European Copyright Act, the rules are outdated and simply do not fit the current models. And considering that there has been gaps, different countries in the EU have started taking action, whether it's Germany, France, in order to tackle these issues. The problem is that then we don't have a European single digital marketplace if all content is subject to different rules. So what the European Union is trying to do is really to ensure that the same rules apply within the EU so that it is easy for you to trade. The impact is going to be basically more responsibility for online intermediaries and for online service providers. So more responsibility that will be in relation to what they sell, what they do, what responsibility they have. So at the moment, we are in the middle of a public consultation. So it's really your time to speak up if you're interested in the topic. And the deadline is 8th of September. So you have just over a month to be able to say what you think matters and how it should be applied to the gaming industries. A lot of the key players, whether the big industry players or slightly smaller, have replied and asked for a differentiated liability regime depending on the industry. So again, I think it's a good time to participate. If you want to have a quick cheat sheet to see what's included, you'll see, app stores, marketplace, social media. And again, when you think about social media, don't think only about the platforms that do only social media. Because of the convergence of gaming and social media, a lot of games would be included in this. Again, and just to say a final word on the Digital Services Act, a lot of what the Digital Services Act will try to do as well is to fight the dissemination of fake news and misinformation, as well as stopping the spread of illegal content. So it's something that's very, very difficult to do. Because we have so much content generated every day. But again, and there is, of course, a difference between harmful content and illegal content. And it's interesting to see who should bear the responsibility for monitoring, basically, the internet. But this is going to be one of the key issues that will impact the gaming industry. So one to definitely watch out for. Okay, out of EU specific, loot boxes. Paul, all yours.
Thanks, Laura. Well, I'm sure everybody has heard about the topic of loot boxes and the controversy which was caused by the topic, and there have been a number of video games which have been under scrutiny from European regulators. I have included here some news reports about some popular games which had to either change their practices or otherwise which were removed from stores in certain countries, in particular the Netherlands and Belgium, although there have been some other cases in other non-European countries as well, South Korea and so forth. And some of you may be wondering, well, why are we talking about it now? Because the topic of loot boxes made a lot of noise in 2018, 2019, and not so much now. However, the topic has come up many times again under the radar of the authorities. And if you look at the next slide, there have been, for example, class actions which have been filed against Apple, against Google as well in the US 1 month ago. So I guess we'll see how this topic goes. There has been as well a European report which was published recently. So it's a European report which was commissioned by the European Parliament, and it looked into the topic of loot boxes, and the report found that the topic of loot boxes and generally how games are being monetized, game design and so forth, they should, according to the report, they should be addressed at the European level, and they should be tackled from a consumer protection approach, according to the reports. And according to the report as well, those who drafted the report say that the European Commission should be taking the lead on this. So it's interesting. It's interesting to see that the topic is still being actively considered. If you look at the next slide as well, in the United Kingdom, there has been recent discussions as well on the topic of loot boxes. There has been a report from the House of Lords as well, which found that the topic of loot boxes is unaddressed under current gambling laws, and the House of Lords strongly urges the UK government to take action and to regulate. And the UK government, in response, has said, well, they are actively looking at the topic of loot boxes, but before they take any action, or before they issue any regulation or any legislation, they actually want to carefully consider the topic. So they want to first gather evidence, talk to the industry and so forth before they take any action. But then, even though there is no immediate action which has been taken right now by the government, it shows that this is something which everyone should keep on their radars, because it's likely that there will be action or anything else which will be taken by the government in the next few months, or maybe at the beginning of next year.
Yeah, definitely one to keep on the radar.
And there is a link as well on both slides, actually, if you want to find out more on the topic. PEGI ratings, PEGI rating as well. I'm going to be very brief here. There is a link if you need more information. And what I wanted to mention here was that loot boxes as well has now its own category under PEGI ratings, and ESRB ratings in the US as well. So under the ESRB ratings, it would be classified under in-game purchases. And then for PEGI, it would be listed as in-game purchases or paid random items. So yeah, now games have to disclose whenever those games are being rated. They have to disclose whenever loot boxes are being used in-game. Moving on to the next slide. That's for you, Laura.
Thank you. So yeah, we just wanted to have a quick look. We know that not everyone listening is going to be interested in AR or VR, but there are some issues that we just thought would flag. Again, a lot of these issues are actually already issues in traditional gaming, but they are going to be enhanced in AR and VR. So this is why we thought we'd flag them. So first of all, just to bounce from the the PEGI rating and the age classification slide that Paul was talking about, there is a possibility that AR and VR ratings may be higher than the 2D screen format due to the immersive nature of the game. So again, one thing to consider at the time when we're looking at all of this is, does the physical or real nature or dimension of AR and VR changes the age classification? Another one is really, again, it's same thing for every game, but considering the physical aspects of AR and VR, are there additional questions of liability for health and safety? So in some countries, these can't be excluded. So you can't just say in your terms and conditions, we will not be responsible for anything that happens to you when you play this game. It's not possible. So considering the risk has increased, it might be that you're looking for better insurance. But again, you can't just have a trick of putting it in your T's and C's. Another thing that is applicable everywhere but will be enhanced and heightened in AR and VR is what happens to disputes or crimes online. What is the applicable law? And again, because the possibility of harassment will be one more likely in VR when it's more immersive, but also more real, therefore potentially causing more stress and loss. Virtual theft, what happens to virtual goods? What happens to virtual mugging? Who is responsible? So there are a few cases actually that have been dealt with already in different countries. In the UK, I think there was an individual who hacked into Zynga and transferred 400 billion of virtual poker chips. And I think the person who did this is now in prison. But again, a good question of who owns what. Is it real property, and what law will apply if it's relevant? And it's not the last thing, but one of the last key issues to point out is going to be moderation and user-generated content. So I spoke about it on the previous slides, but again, in VR and AR, this is likely to be heightened, and therefore it might be that we require from the gaming companies more ownership, responsibility, and active moderation versus what is being done now. This doesn't, this actually is accompanied by other issues considering the state of the law. But it's something that you have to think about. How can we monitor it considering the potential harms that can be done? And it goes back to, a liability for health and safety. So, and then, all the general IP rights will be another question in VR. So think about it as not new issues, but enhanced issues.
And just to emphasize a point that you just raised as well is that the issues which you have listed here, they're not specific to VR, right? They also apply to AR, and there has
Yeah.
been a lot of litigation as well in relation to AR games. I'm not going to name the game in question or the developer, but then I guess it's easy to guess which one I'm referring to, where there has been a popular mobile game which integrates AR and because that game led gamers to certain locations where they could capture a specific virtual animal and so forth. And because the location was not really a good one from a physical perspective, so the location which was on the map was, for example, a real life church or other private properties and so forth. Well, that has led to a number of lawsuits and lots of litigation because the owners of the property were not too happy, of course, to see gamers flocking into properties, those private properties, just to collect
Mm.
a virtual animal. So be careful of be careful of health and safety, and be careful as well. Are there any issues as well in relation to locations that appear on the map? Maybe even the map itself. Well, do you have the right to use the map, or are you just taking a map online and so forth? There may be copyright issues as well surrounding that. And make sure you have, of course, the authorization to tell users to go to certain locations, or make sure it's a public location otherwise.
Yes, otherwise there'd be, you're right, trespass is quite a serious potentially issue depending on where you are. So Paul, I think we have now 4 minutes left. So I think we'll be very brief on the next slides. And again, please feel free to reach out. This is just raising issues. But Paul, on resale of digital content, can we do that?
Yeah, maybe I'm going to frame it more generally because now there has been a lot of focus on cloud services, subscription services, and so forth. And there have been lots of developments, lots of announcements recently, lots of companies which are entering into the space as well, and we're seeing lots of exciting opportunities, new ways as well for companies to promote their service, to reach out to users and so forth. And this case, which was issued by the High Court of Paris, is very interesting because basically the High Court of Paris said that European consumers are legally free to resell digital games that they have bought on a digital platform in the same way as they should be able to sell packaged physical games. So it's a very interesting development because in the digital space, what happens is that when you buy a game, well, it's yours, it's tied to your account, and there is typically no way for you to resell it. But then this decision from the Paris High Court says otherwise. Now, some of you may be wondering, well, why haven't we seen more impact about this decision? And the reason for that is that this decision has been appealed, and therefore the decision by the court has been suspended until the appeal has been concluded. So it's I wanted to mention this case because it's really watch this space. There may be big changes coming up. Let's see what the Paris Court of Appeal thinks about it, and maybe it might even be brought at the European level. I don't know.
Yeah, watch the space. And I think just the last things to finish is really, again, it's back to the EU just because the European Union in general affords a lot more protection on consumers. Therefore, these are the standards in a way that you have to meet. And it's likely that if you meet the European standards in digital and consumer protection, you're doing quite well on a global basis. But the reminder was really that whether it is for advertising, for in-app purchases, whether it's online games or app-based games, there are rules that you need to comply. And at the moment, we see that this is not always happening. So it's just a reminder, and again, you'll see the slides that, games advertised as free should not mislead consumers. There shouldn't be extortions to children to buy items. Consumers should be informed about when they're buying, how they're buying it. There's lots of very clear rules, and at the moment there is quite a lack of transparency about how games are being monetized, and a lot of the games are being advertised as free, but of course nothing's free. So I think it's very important to recognize that misleading commercial practices, whether we see them as such or not, are very strictly regulated, and that the gaming industry, although it has been for a while not on the, I was going to say, the regulator's radar, it is now. It is very, very much now, as the industry is growing, exponentially every year, and even before COVID, but especially in COVID. So again, pay attention about, what happens when you do distance selling. Can consumers return the goods if it's packaged or boxed games? What can you do about if it's digital content? What are your rights and duties? And also make sure that all advertisement complies with the advertising codes, whether it's broadcast or non-broadcast. And I think, ta-da, we just arrived at 50 minutes. So the last thing, so basically just to recap on the list of what we would like you to have on your radar, is that one, privacy challenges, although most companies think that they're doing really well on GDPR side, as Paul showed, whether it's for children or just in general in-game data, it's not there yet. There's lots of European digital regulation that will affect the gaming industry. You have to look at it now, because some of it is in force already, and some of it is coming up over the next few months. Loot boxes, PEGI rating, although again, these are not new challenges, they are new positions, whether it's guidelines or legislation coming in that way. VR issues, again, just something to think about. Resale of digital content, watch the space, because this would be a game changer for the industry, depending on what the French Court of Appeal decides. And the general health check on consumer protection. Be careful, because there is a lot of legislation around that you need to be aware of. Paul, did I forget anything in the recap?
No, I think that's about right. Yeah.
Great.
So thank y'all very much. So we do have questions, but at the same time, we've got limited, time. So let me see.
Yeah, I saw there was a question which says, given that we operate in a global market, what's the best way to proceed? And I guess that's also the reason why we focus a lot on the European regulations, right, during this presentation, because the best way to proceed would be, well, if you can comply with the stricter standard, then it means that you cover all your different regions. Whereas if you just say, well, I just look at the law of one specific country, then that's good for your commercialization in that specific country. But then if you decide to expand and to reach out to other countries, that's when you would have to anyway comply with those different regulations. So I guess if from the beginning you say, well, what is a stricter standard? Oh, let's just apply it, and we give consumers the benefit of those stricter standards, then it's good commercially, because you give customers something extra, and on top of it, you comply with the different laws and regulations.
So what we're going to do at this point, Paul and Laura are on the Discord, and so I will take these questions and bounce them over there to the post-session chat room, and they'll be around for a little bit to answer any further questions that you have. But there you go. If you've got questions for them directly, you can reach out to laura.berton@fieldfisher.com or paul.lanois. I don't know how to do that, Paul.
You did well.
At fieldfisher.com. Thank you both so much for taking time to do this. It's always something that we do end up getting a lot of questions about, even at my firm. And I'm like, I'm not an attorney. That's not what I do. So it's always good to get you all coming in here and answering them directly from the teams.
Thank you so much for having us. It's been a pleasure and a privilege. So thank you very much, and best of luck for the rest of the day.
Appreciate it. Y'all take care.
Bye-bye.
You too. Bye.